At length, on Friday, Council brought to your attention the exact words he used, Your Lordship. But what you are not told is that happened at the tail end of the proceedings, Your Lordship, at the closing submissions of the Governor, Your Lordship.
Yes.
Equally, Your Lordship, you've been told that Senator Halwale raised a point of order about the issue, Your Lordship.
Yes.
But, Your Lordship, that issue is being raised at the time when the Speaker has put the question, Your Lordship. And, Your Lordship, the rules of the Senate particularly Standing Order 96 of the Senate Standing Orders,
Yes.
provides that no senator shall speak to any question after the question has been put by the Speaker, Your Lordship. And in the same regard, Your Lordship, you will have time to look at the answer for that particular moment.
Yes.
What happened is that the Speaker actually ruled the said senator to be totally out of order, Your Lordship. The rules do not allow that, Your Lordship. So then what does that mean, Your Lordship? If you raise the issue of sub judice at the tail end in your closing submissions, Your Lordship, because having not raised it at a preliminary stage, Your Lordship, so that the Speaker rules on it, it simply means that as part of your closing arguments, you raise that issue, Your Lordship. So that means when senators are voting, then they consider it as part of your general submissions, Your Lordship. So if they find to the contrary, or if they vote otherwise, Your Lordship, then how do you come and say that this issue was raised and was not considered, Your Lordship? Is it an appeal? What exactly is it, Your Lordship?
You have 10 minutes.
Yes, Your Lordship. I will not speak much to that issue. I will quickly move to the substantiation of particulars, Your Lordship, whether the threshold is met. Your Lordship, from the rest of it, I was surprised when my senior on Friday asked you to conduct both a procedural and a merit review of that decision in the Senate, Your Lordship.
Yes.
Your Lordship, a merit review of that decision means that this court is going to sit as the Senate. That this court may substitute its own decision with the decision of the Senate, Your Lordship. I submit that that is not what the law provides.
Yes.
Your Lordship, by way of example, the law only requires, and I'll just avoid quoting the laws, that the allegations are substantiated. That's section 33 of the County Government Act. The word is substantiated. And in any case, Your Lordship, even one ground, the substantiation of one ground, is enough to impeach the governor, Your Lordship. Your Lordship,
Yes.
there is no evidence of bad faith or ill intention on the part of the Senate. And in this regard, I make reference to the Supreme Court case in the Mike Sonko decision, where the court actually found that there was no evidence of a predetermined outcome, Your Lordship.
Yes.
And Your Lordship, just to put it into perspective, I am wondering what will happen one day if now the Senate acquits, and maybe at that time the Assembly comes to you and tells you the Senate force the Senate decision to acquit and say that the governor should have been impeached, Your Lordship. And then ultimately, maybe this court is going to make a finding that that of the members of the assembly, and the speaker approves that motion. It is then tabled on the floor of the House.
Yes.
And pursuant to Standing Order 65(2), the mover gives 7 days notice calling for the impeachment of the governor. Pursuant to Standing Order 65(3), my Lord, upon the expiry of the 7 days,
Yes.
the motion is placed on the order paper and disposed of within 3 days. So, my Lord, the entire time that the county assembly has, right from filing that motion with the office of the clerk, to giving notice, to consideration and passing a resolution,
Yes.
either in support of or to defeat the motion, is 10 days. 10 days is the maximum amount of time that the county assembly has. That upon approval, if that motion succeeds at the assembly with the 2/3 threshold,
Yes.
that resolution is communicated to the Speaker of the Senate within 2 days, pursuant to Section 93 of the County Governments Act, my Lord.
Yes.
And the Senate convenes, the Speaker of the Senate convenes the Senate to consider that motion.
Yes.
So, my Lord, the role of the Assembly is to initiate the impeachment process.
Yes.
My Lord, the decision in Martin Nyagawa, that is Civil Appeal number 21, it is in our list and bundle of authorities at page 111, spilling over to 112.
Yes.
This decision, my Lord, by the Court of Appeal, holds that the role of the Assembly is to initiate the impeachment process.
Yes.
And, my Lord, if I can read verbatim, there are 3 sequential steps to be followed. First is initiation of a motion to remove the governor by a member of the County Assembly. Second is consideration of the motion and a resolution by 2/3 of all the members of the Assembly.
Yes.
And that the Speaker of the Assembly is to forward the County Assembly's resolution to the Senate for hearing of the charges against the governor. So, my Lord, what is the role of the Senate? We submit that the role of the Senate, my Lord, pursuant to this decision, is to hear the charges against the governor. Section 33 of the County Governments Act, my Lord, and Rule 2 Rule 2 of the Senate Rules of Procedure
Yes.
equally provides that the role of the Senate, my Lord, is to investigate the charges and to determine whether the particulars have been substantiated. Once Senate considers the impeachment charges, my Lord, and makes a resolution,
Yes.
the dispute might find itself to court, as we have found ourselves, my Lord, before you. The question that then arises is, what is the role of the court?
Yes.
My Lord, we submit that the role of the court
is to review the processes at the Assembly and the Senate to establish whether individual rights of the petitioner have been violated. Ordinarily, my lord, that would be the role of this court. But my lord, this is no ordinary petition.
Yes.
Because the petitioner, my lord, does not complain about the processes at the Assembly. My lord, I'll refer you to the further affidavit.
Just a moment.
Can I proceed, my lord?
No, just a moment. Yes, proceed.
My lord, I refer you to paragraphs 91 and 92 of the petitioner's further affidavit.
Yes.
My lord, I'll read verbatim what the petitioner says. Imperative to note is the fact that the amended petition does not at any point make any allegations against the County Assembly of Meru, and neither are there any relief sought against the fifth interested party, which is the County Assembly of Meru, as per its assertions and the paragraph of its affidavit. That paragraph is omitted. At paragraph 92, my lord, the petitioner goes on to say as follows: I could not help to note that the fourth, fifth, and sixth interested parties, through their responses, have framed a new cause of action against them and sought to respond on the very extraneous issues unrelated to the issues raised in the amended petition. If you turn to the next page, my lord, at paragraph 29, the petitioner deposed as follows: there are notable fact and distinction is that the cause of action in the instant petition arose at the Senate and not at the County Assembly. My lord, what is this court supposed to make of those words, those depositions by the petitioner under oath?
Yes.
My lord, the petitioner has made no allegations against the Assembly. The petitioner seeks no reliefs against the Assembly. The petitioner does not complain about the processes of the Assembly.
Yes.
And even faults the Assembly for responding on what she calls extraneous issues that are unrelated to this petition. So, my lord, as you exercise your role, as you sit as an arbiter over this matter,
Yes.
we submit, my lord, that your role is only limited to reviewing the processes at the Senate and not at the Assembly.
Yes.
My lord, the province of this court, as we are told, is Mutembei. I'll take you back to that authority, my lord.
Yes.
Mutembei, page 112, paragraph 32, tells us that the province of the court is solely to decide on the rights of individuals and not to inquire how the County Assembly and Senate perform duties in which they have discretion. My lord, in our case, it is only the Senate, not the County Assembly, because there are no allegations. The petitioner complains not against the County Assembly, and therefore your role is only limited to the procedure at the Senate. My lord, if you look at the amended petition, Who are the parties, my lord? It is Honorable Vmwangza's petitioner was the Speaker of the Senate. The County Assembly is a party, my lord. I believe this is uncontested. We became a party on account of the oral application for raila reviewed on the 18th of September, on the 18th of December, my lord. I'm sorry. My lord, if you look at the authority, at the decision in Martin Nyagawambora, Civil Appeal number 21, is appearing on page 104 of the Assembly's list and band of authorities. The County Assembly was the 6th respondent.
Yes.
If you go to Sonko, my lord,
Yes.
just a moment, my lord. The decision in Sonko, my lord, the County Assembly was the third, the Nairobi City County Assembly was the third respondent.
Yes.
The Speaker of the Nairobi County Assembly was even sued as the second respondent. Unlike in these two cases, my lord, the petitioner has no cause of action against the Assembly, and therefore, my lord, it must be that in exercising your jurisdiction,
Yes.
the petitioner has confined you to the processes at the Senate.
Yes.
My lord, what is the review jurisdiction of this court? What is the remit or the extent of the review jurisdiction by this court? Our position, my lord, is that the jurisdiction of this court does not extend to a merit review of the decision or the resolution by the Senate. For now, we are not bothered with the Assembly, just with the Senate. Because, my lord, if this court, my lord, was to conduct a merit review
Yes.
of the decision of the Senate, this court would be supplanting its own decision, substituting the decision of the Senate for its own.
Just a moment. Let me take your time off. Let's go to the amended. Let's go into the amended petition, and we can look at the prayer. I'm interested in prayer number I.
Prayer number I, I'm there, my lord.
Yes, please.
Yes.
An order of Sachi-Orarai it's been spelled the way we should pronounce it, to remove this honorable court and quash the decision and or resolution of the Senate made on 21st August 2024, resolving to remove the petitioner from office by way of impeachment. That was initially a judicial review prayer, remedy, relief. Then it was constitutionalized. Can that be issued in a procedural case?
Indeed, my lord.
So,
If I can explain, my lord.
yes.
This court, in reviewing the procedure at the Senate, if this court was to find, my lord,
Yes.
that the rights of the petitioner were violated,
Yes.
by way of example, if this court was to find that the petitioner was not afforded an ample opportunity to present a defense. That's a violation of a right to fair hearing.
Yes.
This court can quash that resolution.
So let's look at the previous prayer, which is prayer H. It is declaratory in nature, though.
A declaratory, that is order number H?
Yes, H.
Yes.
Please read it.
A declaration that the Senate, in its evaluation of the impeachment proceedings before it, failed to properly assess each of the specified grounds and determine if they collectively or individually constituted gross violation of the Constitution, warranting the removal from office by impeachment of the governor. Hence, the resolution of 21st August 2024 does not meet the threshold for impeachment set out under Article 181 of the Constitution, hence the same be and is hereby certified.
To the fifth IP's mind, is that merit or is that procedural?
That is merit, my lord, and that is why we invite you.
Okay, so your time is back on.
Yes, my lord. My lord, those two prayers, foremost, are sought against the Senate. It is not a party. I think it is important that we clarify that. Two, this is an invitation, my lord, for you to look into the merits of the decision by the Senate. An invitation we humbly urge you to decline. My lord, we find strength in that submission, my lord, in Martin Jaga Wambora, page 112 of our submissions, my lord, our list and other authorities. The province of the court is solely to decide on the rights of individuals and not to inquire how the county assembly and senate perform duties in which they have discretion. We find further strength, my lord, in the Sonko decision, paragraph 112, where the Supreme Court stated as follows, and I quote, likewise, in Justice Kariuki Mate and another versus Martin Nyega Wambora and another Supreme Court petition number 32 of 2014, this court signaled that it would be reluctant to question parliamentary procedures as long as it did not breach the Constitution, and that the mandate of the courts is restricted by the doctrine of separation of powers to deciding on matters of individual rights and fundamental freedoms, and not to inquire into how the county assembly and senate perform duties in which they alone have discretion, or to review the merit of the decision by the county assembly and senate to impeach government. We submit, my lord, that you are guided by those two authorities.
Yes.
My lord.
I will record you are bound.
Indeed, my lord.
Yes.
Bound. Bound is the word.
Yes, proceed.
My lord, in exercising that review jurisdiction,
yes,
to relook or to review the processes at the Senate, we submit that, my lord, in that very limited review that the petitioner has confined you to, in which, for the record, we have no problem with, this court, my lord, should also be aware,
yes,
that the role of the Senate is not to reassess the procedures at the Assembly.
yes,
Such that, my lord, all the instances where the petitioner faults the Speaker of the Senate or even the Senate for not correcting what, in the petitioner's views, were errors at the Assembly, my lord, we submit that that is not the authority of the Senate. The Senate has no authority to review the procedures at the Assembly. Perhaps that is why, my lord, in that sequential or hierarchical separation of the distinct jurisdictions of all the three bodies, this court ultimately has the power to look at the procedures at the Assembly. The Senate does not have that power.
So let's assume that the county assembly, let's give a situation that would never occur.
Is my time closed, my lord?
Yes, it is. So the county assembly does not, there is no mover. They just go straight to the end. There was no vote, no nothing. Just the Speaker of the County Assembly forwards the decision to the Speaker of the August House. Are you saying that, and then it is raised as a preliminary issue? Are you saying that in that instance, the Senate would not be able to say there was such and such procedure established by the law and by the County Assembly's own standing orders, it was not followed, breach of procedure, we are not hearing this, we reject it?
My Lord, my understanding is one,
Yes.
that any grievances that ought to be raised to the Assembly cannot be taken on appeal. Such that, my Lord,
Yes.
Senate does not sit on appeal of the decision by the County Assembly. The role of the Senate under Section 33, and also I believe Rule 2 of the Senate Rules of Procedure, is to investigate the charges and to determine whether the same have been substantiated. If